So, a pleasant day to everyone. So, this is the last group to present. So, our topic for today is all about the petition for executive clemency and parole. So, in this discussion, we will be able to know a formal request made to the President, especially here in the Philippines, to grant mercy to a convicted individual. So, it is often filed when the person has already served a portion of their sentences and when they show a good behavior or there are humanitarian grounds such as old age, illness, or exceptional circumstances. So let's start. So in our first part, we have here a filing of petition. So as you can see in our presentation, this is a proper or formal filing of petition for executive clemency addressed as follows and shall be submitted to the board before the question of said clemency will be considered. So as you can see, it means that in order for the board to consider the question of clemency, so the petitioner must first submit a formal petition for executive clemency, that it should be written in a specific format and should be include certain information and must be addressed to a specific person or organization such as the board that is responsible for considering the clemency request. In our next part, we have here the contents of petitions. So these are the contents that must be included in filing for petitions. So a petition for parole or executive clemency shall state the following. So, of course, the name of the prisoner, his age, previous criminal record, if any, whether a Filipino citizen or a foreigner, if a naturalized Filipino, his former nationality rather, and the date of his naturalization, his previous occupation, place of residence, present crime for which he was convicted, the trial or appellate court, his penalty of imprisonment, fine, indemnity, and the commencing date thereof, and also the jail or prison to which he was committed and or where he is presently confined, and the date that he was received for confinement and the grounds upon which executive clemency is being asked and certification from the trial court that his case is not appealed. So in the next part will be discussed by Mr. Villaperte.
And today I'll be discussing the supporting documents of petition for absolute pardon. So, affidavits of at least two responsible members of the community where the petitioner resides. The affidavits shall, among others, state the petitioner has conducted himself in a moral and law-abiding manner since his release from prison, and shall indicate the petitioner's occupation and his activities, including our religious involvement. So, affidavits of two responsible community members are crucial for a pardon petition. So, these affidavits attest to the petitioner's moral character and law-abiding behavior since the release from prison. They should detail the petitioner's occupation and involvement in social and religious activities within the community. And the clearances from National Bureau of Investigation, the Philippine National Police, the Prosecutor's Office, the Municipal Circuit Trial Court, the Municipal Trial Court, the Municipal Trial Court in cities, the Metropolitan Trial Court, and the Regional Trial Court where the petitioner resides give uh, on this matter. So the clearances from various government agencies, including the National Bureau of Investigation, the PNP, the Prosecutor's Office, the Municipal Circuit Trial Court, the MTC or the Municipal Trial Court. So MTC in the cities, and also in regional trial court are ano are are very essential, and these clearances verify that that the petitioner has no pending cases or warrants of arrest and has maintained a clean record since their release. And next is supporting documents of petition for absolute pardon. So proof of payment of indemnity and or fine or in lieu thereof certification from city or municipal treasurer or probation and parole officer or his financial condition and proof of service of sentence or certificate of final release and discharge or court's termination order of probation. So to demonstrate that the petitioner has fulfilled their legal obligations, so proof of payment of indemnity and or fines is highly required. If they are unable to pay, so a certification from the city or municipal treasurer or probation and parole officer verifying their financial status is necessary. And also additionally, proof of completed sentence including a certificate of final release and discharge or a court's termination order of probation is very essential to confirm that the petitioner has served their time and is no longer under any legal restrictions. And next is a referral of petition for absolute pardon to a probation and parole officer. When a petition for absolute pardon is received, the board refers it to a probation and parole officer or the PPO. The PPO investigates the petitioner's behavior, activities, and social economic conditions before conviction and after release from prison. A report on the findings must be submitted within 15 days of receiving the referral. So once um, the once a petition for absolute pardon is filed, so the board assigns a probation and parole officer or the PPO will going to conduct an investigation, and the PPO delves into the uh, petitioner's past behavior, their activities, and socioeconomic circumstances both before and after their release from prison. And the PPO is required to submit a comprehensive report detailing their findings within a 15-day time frame from the date of referral. So,
Ma'am. So today I'm continuing the report. I'm tackling about the referral of petition for executive clemency parole to other government agency. So there are two topics. Then I'm just gonna elaborate this for quicker and more simpler explanation. The first one is Board to Secretary of National Defense. It means that a petition for executive clemency must be sent to the Secretary of National Defense for review and recommendation if the crime involved threatens national security, public order, or violates international law. This ensures that sensitive issues related to these areas are carefully considered before granting clemency. Then the second one is Commission of Election or COMELEC. So it means that if the petitioner has violated election laws, their petition for executive clemency or parole must be sent to COMELEC or Commission on Elections for a favorable recommendation. Regardless of the offense, the petition may also be referred to a parole and probation officer (PPO) for an investigation into petitioner's behavior, characters, and health. The PPO must submit a report including an NBI background check within 30 days. If the petitioner is a foreigner, the petition is referred to the Department of Foreign Affairs or DFA for their comments and recommendation. Then the second one is the review of cases of executive clemency. Extraordinary circumstances, the board shall recommend to the President the grant of executive clemency where any of the following extraordinary circumstances are present. Number one is the court, appellate court is the decision recommendable, the grant of executive for the inmate. Second one is under the peculiar circumstances of the case, the penalty imposed is too harsh compared to the crime committed. Number three is evidence which of the court failed to consider before conviction which would have justified an acquittal of the accused. Number four, inmates who were over 15 years but under 18 years of age at the time of commission of the offense. The fifth one is inmate who are 70 years old and above whose continued imprisonment is inimical to their health, recommended by the physician for the Bureau of Correction Hospital and certified under oath by a physical designated by the Department of Health. Number 6 is inmate who suffer from serious, contagious or life-threatening illnesses, disease, or with severe physical disability such as those who are totally blind, paralyzed, bedridden, etc. as by the physician designated the Department of Health. Number 7 is alien inmates who diplomatic considerations and amnesty among nation necessity review. And number 8, the last one is such other similar circumstances whenever the interest of justice will be served thereby. Thank you, ma'am, and goodbye.
Good day, everyone. So my report is the continuation of the report of Villacorte. So other circumstances, if none of the extraordinary circumstances is present, petitions for executive clemency may be reviewed if the prisoners meets the following minimum requirements. Number 1, for commutation of sentence, A, at least 1/3 of the definite or regulate prison terms. B, at least 1/2 of the minimum of the indeterminate prison term of aggregate minimum of the indeterminate prison terms. C, at least 10 years for inmates sentenced to 1 reclusion perpetua or 1 life imprisonment for crimes offenses not punished under Republic Act number 7659 and other special laws. D, at least 13 years for inmates whose indeterminate and or definite prison terms were adjusted to definite prison term of 40 years in accordance with the provisions of Article 70 of the revised penal code. So all of these requirements ensure that inmates demonstrate a significant portion of their sentence before being considered for clemency. So number 2, for conditional pardon, an inmate should have served at least 1/2 the minimum of the original indeterminate and or definite prison term. And number 3, for absolute pardon, A, after he has served his minimum sentence of granted final release and discharge of court termination of probation. However, the board may consider a petition for absolute pardon even before the grant of final release and discharge under the provision of Section 6 of Act number 4103 as amended as when the petitioner. B, I is seeking an appointed elective public position of reinstatement into the government service. 2, needs medical treatment and abroad which is not available locally. And 3, will take any government examination. Or 4 is immigrating. So let's proceed to grant of parole. Whenever the Board of Pardons and Parole finds that there is a reasonable probability that If released, the prisoner will be law by obedient that the release will not be compatible with the interest and welfare of societies. The Board of Pardons and Parole can grant parole if it determines there is reasonable likelihood that the inmate will abide by the law upon release and that their release in the best interest of society. This emphasizes public safety while allowing for rehabilitation. So, next, the disqualification for parole. So, number 1, those convicted of offenses punished with death penalty of life imprisonment. Number 2, those convicted of treason, conspiracy, or proposal to commit treason or espionage. Number 3, those convicted of misprision, treason, rebellion, sedition, or coup d'etat. Number 4, those convicted of piracy or mutiny on the high seas or Philippine waters. Number 5, those who are habitual delinquents, for example, those who within a period of 10 from prisoner last conviction of the crimes of serious or less serious physical injury, robbery, theft, estafa, and falsification are found guilty of any said crimes a third time or oftener. 6. Those who escape from confinement or evaded sentence. 7. Those who have been granted conditional pardon by the President of the Philippines shall have violated any of the terms thereof. 8. Those whose maximum term of imprisonment does not exceed 1 year or those with definite sentence. And 9. Those convicted of offenses punished with reclusion perpetua or whose sentences were reduced to reclusion perpetua by reason of Republic Act number 9346 enacted in June 24, 2006, amending Republic dated January 1, 2004. And lastly, number 10, those convicted for violations of the laws on terrorism, plunder, and transnational crimes. So these disqualifications are designed to ensure that individuals who have committed serious offense or demonstrated a disregard for the law do not receive the opportunity for early release.
So, good afternoon everyone. My topic is all about parole supervision. So, number 1, post-release supervision. Parolees are placed under the supervision of a probation and parole officer until maximum sentence expiration. So this means that the parolees and the probationer stays under the supervision of the probation and parole officer until their sentence expires or ends. Number 2, release document. The board sends a copy of the release document to the parole. The parolee must present themselves to the designated probation and parole officer within the specified time frame. Failure to report within 45 days is reported to the board. So this one, the release document, so parolees must report to their assigned parole officer so they won't have to face such consequences. Number 3. So number 3 is compliance with terms. So parolees must adhere to the terms and conditions of the release document. The board can modify these terms upon recommendation. Prior approval is required for changing residence. So kaning compliance with terms kay there are outlined guidelines before a parolee or a probationer can change their residence. So they must inform their probation or parole officer first before changing their residences. So next one is the travel restriction. So travel within the operational jurisdiction for up to 30 days can be authorized by a chief probation and parole officer. Longer travel or travel abroad requires approval from regional director. So This requires approval from probation officer if it is for 30 days lang. So if it is more than 30 days and it is abroad, this requires the approval of the higher or the regional director of the probation officers. So next one is I'll be discussing about infraction and violation. So the first one is progress report. So a progress report is submitted by a probation and parole officer or PPO if a parolee commits another offense during their parole period. So next one is infraction report. An infraction report or IR is submitted if a parolee is convicted of another crime or violates the terms of a condition of their release. And lastly, board of action. So upon receiving an IR, the board can order the arrest of and recommit of the parolee. If recommitted, the parolee must serve remaining portion of their original sentence. So first one is, so what is the progress report? So if a progress report is a report created by the parole or probation officer to be submitted to the higher authorities to alert them of the potential violations that the probationer or parolee has committed. So the IR or infraction report is submitted if the parolee violates a condition of their release. So such as missing the curfew, unauthorized travels. So that are some of the examples of the violation that contains the infraction report. So this report is formal notification of the parole board about serious breaches. So this informs the parole board, which can result to having faced consequences. So the last one of the infraction and violation is the board of action. So upon receiving the infraction report, the parole board can order the arrest or the recommitment of the parolee or pardonee. So what is recommitment? So recommitment is the prisoner is brought back to prison to serve the remaining sentence. So for an example of this, if a parolee has a remaining sentence of 4 years, then released on a parole or probation, then he will return to the prison to serve them inside in an institutional correction. So next one is the cancellation of pardon and parole. So grounds for cancellation of pardon and parole. So the board can cancel a pardon or parole if the parolee provided false or incomplete information. So recommitment. So as I have stated, recommitment is putting a prisoner back into the prison. So if a parole is cancelled, the parolee may recommitted to prison. Future parole after serving 1/4 of the unserved portion of their maximum sentence, a recommitted parolee may be considered for a new parole. So this one talks about the cancellation of pardon. So grounds for cancellation. So the parole board has the authority to cancel the parole or pardon if the parolee provided false information or incomplete information during the parole process. So for example, they lied about their criminal process or criminal history. The next one is recommitment. So recommitment is putting back the prisoner into the institution to serve the remaining sentence. Then the last one is if parolee is back to prison. So it is the future parole. So future parole is when a prisoner is back to the prison, he can apply for a parole again after serving one-fourth of the sentence. So an example of this, if he or she has a remaining sentence of 4 years, they should serve the sentence of 1 year before they are able to apply for another parole. So next one is The substantial compliance. So substantial compliance. The Board of Pardons and Parole, or BPP, will issue a certificate of final release and discharge to a parole and pardonee upon the recommendation of the Chief Probation and Parole Officer, or CPPO, if the individual has substantially complied with all conditions of their release. So this one is substantial compliance. So if a parolee or pardonee follows most of the rules and conditions of the release, so the BPP can issue a certificate of their release, ending their parole and pardon. So this based on recommendation of the officer that is supervising them. So next one is the early release. Early release, in some cases, the BPP may issue a certificate of final release and discharge even before the expiration of maximum sentence pursuant to specific legal provisions. So early release, in certain cases, the BPP can release full sentence if allowed by law. So, next one is the final release. So final release, upon receiving the certificate, the parolee or pardonee is finally released and discharged from all conditions of their release documents. So final release, once a certificate of final release is issued, the person is freed from all conditions of their parole and pardon. So this means that there are no longer pardonees or parolees, then no more supervising officers. Then lastly is the accessory penalties. However, any accessory penalties imposed by the court that have not been expressly remitted in the release document will still apply. So an example of this, if there is an accessory penalty that is applied, like if you are not allowed to hold a public office, then if not specified in the release document, then you are still not able to hold a public office due to the accessory penalty. So it will remain, or it will still act, it will still be enforced.